Now, just 3 quick points. I don't want to take time of the participants with my lecture. Just 3 quick points. One is, the Singapore example shows how you can, in a very short span of time, reach a commanding level of being an arbitration hub. And the reason why Singapore was able to make it is because of government support, which came to its way. And the way it promoted its institutional arbitration through its institutional centers. Now, if you look at India, we've got a rich pool of advocates, we've got all the other facilities, etc. But now I think the government has also realized the importance of giving the push. And therefore, 2 things have happened. One is, there is more frequent amendment of legislation, which shows that it is trying to keep in touch with the latest in arbitration practices. Second, institutional setups are coming up. For example, the IMC Hyderabad, which is there, Mumbai International Arbitration Center. So that's the second important point, which is there to show that India is taking this seriously and could become a hub. And third, the elephant in the room, which is one of the questions here also, is, I think, if parties make India a seat of arbitration, it'll be better and it'll make it a hub there. And for that, the elephant in the room is enforcement. We have to get our act together in enforcement of awards. And if we are able to do that properly, and also courts quickly setting aside of arbitral awards, I think we are way home. So without wasting more time, I'll come straight to the first question with Vikash. And I just wanted to ask you, Vikash, that what is it that makes for a truly arbitration-friendly setup or environment? And how would you say, compare India with, say, Singapore, Hong Kong, etc., which have been the recent hubs?
Thank you, sir. Thank you, sir. Thank you, everyone, for being here. I think I'm assuming that the audience over here is quite well informed in terms of knowing what arbitration is and how it is playing out in India. Honestly speaking, I'm not going to say anything new. In fact, while I was reading through it, I came through a quote from our Fali Nariman, and way back in 1994, even before the 1996 Act came, he said that the Indian legal system has laws which are pro-arbitration, but the Indian sentiment, that is what abhors the finality through arbitration. While of course it has changed over a period of time, but we're still, like sir just mentioned about the popularity or the effectiveness which SIAC or at Hong Kong International Arbitration Center and all works, despite the fact that we have DIAC, MIAC and IMC as it is being there, but still if you go through the reports, in fact, which they have published right now in 2022, they had around 5,500 cases, out of which only 122 cases has been decided. So you can see the numbers. So anyone can answer that what needs its certainty, what needs, as I said, is enforceability of an award. And most importantly, in India, you would see that even before an arbitration is initiated, party goes to a court under Section 9 for asking for interim orders. Now, of course, certain amendments came in 2015 and 2019, which made that once you have initiated arbitration, you have to necessarily, once you have invoked Section 9, you have to necessarily go to an arbitration and initiate it within 90 days. Having said that, I would say that what can actually help, and which I think Indian courts are working in that synthesis, is that primacy has to be given to party autonomy. Goes without saying. That is the grand norm behind the entire concept of arbitration. So our laws, our rules, everything has to be in consonance with this golden thread of party autonomy if we want India to become an arbitration hub and friendly towards this mode of dispute resolution. Second would be a non-interventionist judiciary, meaning thereby that the judiciary should not intervene in a Section 11 or a Section 9 or to the least possible measure they should take. The third would be that we need to have a technologically advanced and robust institutionalized arbitration centers, because in India still we are relying on ad hoc arbitration. In fact, more than 80% of the arbitrations in India is still ad hoc based, and they're not institutional. And I think these are the broadly points which I think we would cover and make India an arbitration friendly place.
Great. Thanks a lot. We'll come back to you. This is just the preliminary comments, and therefore I'd come next to Shruti. And the importance of court support in arbitration is what I'd like to ask you. How important that is? How does it compare with, say, UK, Singapore, etc., where there is good court support? What is called arbitranization of courts. Are our Indian courts arbitration sensitive for that purpose?
Thank you for the question, sir. I think this is a good question because, like Vikash mentioned, for India to become arbitration hub, we'll have to look at micro and macro issues. In India, when an arbitration begins, the micro issues start at the time of reference, for example. So that point, and we've seen since 2015 and even earlier, there were a lot of judgments and proactive stance taken by Indian courts to ensure that more arbitral, sensitive party autonomy upholding continues. If you look at, and I'm talking from my experience in before the Dubai courts, specifically in international arbitration and arbitration seated outside India, when we look at the way international courts have come up in these jurisdictions, specifically Singapore, SICC, DIAC courts, ADGM courts in Abu Dhabi, and a lot of Middle Eastern states do have these courts coming up. They are to partner with arbitration and not as such compete or promote them. They specifically provide for certain measures. For example, foreign law qualified lawyers to be able to argue cases before them and present the parties, which currently is not available in India. So if you look at the whole ecosystem, that ecosystem promotes their own countries as hubs for international arbitration. That's one. More foreign judges to be appointed in those international courts, which function on the sidelines of public state courts and are also created with jurisdiction conferred to them by party autonomy in a jurisdictional clause in that particular contractual framework. They also, at a lot of times, for example, SICC for that matter, they give you a lot more room for doing away with the local evidence procedures. So in that sense, I think that brings in a lot more confidence on the investors. And when we talk about arbitration hubs generally, and we take the European example, the Asian example of Singapore, and the Middle Eastern example, we see that there is a whole diverse set and bundling of dispute resolution services. That's something which really comes into picture. Indian courts have tried their best. Indian courts are doing much better than earlier as a matter of criticism, which international perspectives also changed towards India. And if you look at it very closely, since the coming in of Commercial Courts Act, Indian arbitrations before the courts, in fact, all the referrals or allied arbitration-related matters that have come up have really fastened. Their reference, even at the stage of Section 8 or a Section 45, have quickened. The courts are taking very active measures to ensure that any international arbitration or any arbitration which is domestic or an international arbitration seated in India do get resolved even at a very minor point during the arbitration very quickly. Another aspect for judicialization of arbitration and at the same time arbitralization of courts is the enforcement of arbitral awards. That gives the investors and the parties to our international arbitration a lot more confidence in a judicial system. So I think when we talk about arbitralization of Indian courts, we talk about two things. First is a separate set of courts perhaps, which gives a lot more confidence to a foreign investor while making their investment in India and keeping India as a jurisdiction for one, resolving their disputes and for arbitrating their disputes in India.
Thank you very much. Those are very helpful comments and some thoughts coming from there, which we can go on for further question after the initial round. So Shriya, I mean, one of the things which these panelists raised was the issue of institutional arbitration being given more prominence. Why do you think that, and what are the reasons and what are the pros and cons of the existence of ad hoc arbitrations which are there and the prevalence of ad hoc arbitrations which is there in India?
Thank you, sir. That's a very interesting question because as my co-panelists have already discussed the recent steps that have been taken both for institutionalization of arbitration as well as making India a more arbitration-friendly jurisdiction. While globally there has been a shift from ad hoc arbitration to institutional arbitration at a rather rapid speed, despite the existence of various institutions in India, and we go back as early as ICA. We also have DIAC now. We have Sarod, which is specific to the construction industry, and the more recent institutions like Mumbai International Arbitration Center and the IMCA Hyderabad, which is very, very recent. The trend continues to, in India, continues to be preference of ad hoc arbitration. And I think there are a couple of factors that are responsible for that. Firstly, I think mindset. Companies, through their legal counsel, continue to show an overwhelming preference to ad hoc arbitration. And I think mindset goes a long way because it's running with what is familiar and known rather than exploring new avenues. So the second factor which actually contributes to the first factor is lack of awareness of existence of institutions and the framework that they are offering today within India. And apart from lack of awareness at a, say, organization or a corporation level, I would say there's also lack of awareness amongst lawyers and legal teams. Mostly when a deal is going through or, a commercial contract is being closed, it's usually the transactional team that works on it. And based on my personal experience, we do have, our corporate or a transactions team refer dispute resolution clauses to the litigation or the dispute side for our inputs, but the time spent on exploring avenues and the pros of or cons of choosing a particular institution or preferring an Indian institution over a foreign institution, very little time is spent on that. So I think more collaboration between the corporate side and the dispute side is much needed to overcome this issue. Apart from that, cost effectiveness. Definitely, maybe for really large-scale disputes, you may approach a foreign institution. But for small-scale disputes or disputes that are not monetarily huge, referring the matter to a foreign institution can be extremely expensive. And of course, cost is a major deciding factor. And the overall perception today continues to be, and again, that can again be tied in with the mindset and lack of awareness that institutional arbitrations are extremely expensive and ad hoc continues to be more cost effective. And finally, like Shruti said and Vikash and Sir have pointed out the various institutions in different jurisdictions. I think lack of credibility of Indian institutions is something which continues to be a roadblock, and with due respect to the Indian institutions, much is being done to strengthen the framework. But when it comes to foreign presence or visibility and establishing that sort of foreign presence and credibility around the globe, that is still lacking, and I think that is one of the major roadblocks as well. And to answer Sir's second part of the question as to what can be done to actively, encourage institutionalization, especially how to promote Indian institutions, because we do have a pool of, very well-versed lawyers and judiciary and, pool of arbitrators to choose from. So when you compare it globally, the top 5 institutions to who the volume of arbitrations are referred to continue to still remain ICC, there's SIAC, there's HKIC, which is Hong Kong, there is LCIA and SCC, which is Stockholm Institute. Now, when it comes to choosing an institution, what is one looking at? You're looking at overall the general recognition of the institute, as well as the reputation of the institute. Further factors that are considered both by lawyers and companies are, the quality of administration of an institution, as well as their ability to offer, various flexibility in terms of rules, neutrality, etc. The other factor which weighs heavily, and that's based on my personal experience, I would say, is a party's experience with a particular institution. So I believe that the need of the hour today to, much is being done when it comes to strengthening the framework, the rules, the regulations of Indian institutions. But what needs to be done is also creating, presence. They're creating worldwide presence and promoting global presence of Indian institutions. And while I do believe we are on that path, a lot is there in the pipeline before we will be able to establish that global presence to compete with other, institutional arbitration hubs.
Thank you very much. The interesting comments which are there. I'll come next to Samridhi. You're the, and I think amongst the panel, the youngest practitioner here. So what do you feel? I mean, what is your view? How does India compare with the international scene which is there?
So, thank you, sir. I did go through all the comments that were made by my co-panelists. Honestly, I feel while we can continuously criticize the institutional arbitration in India and the mechanism being followed and how it is not equipped, how it is not appropriate for us to choose institutional arbitration yet, I really feel that India as a country cannot be compared to any other countries that we're comparing. Singapore, for instance, is as small as the whole of South Delhi. So if the size, the population, the kind of, like you mentioned in the very beginning, that government has to support the mechanism that needs to be followed, we need to be sure that arbitration is just not a formality and we can actually go on with achieving what is meant to be achieved. So execution of arbitral awards is something that we are looking forward to. But unless we have a proper mechanism, a proper institution, which has been established for a couple of years, we are comparing ICC, SIAC, and Hong Kong Institution of Arbitration to institutes in India. Institutes in India have been set up, 5-6 years ago maximum? And ICC and SIAC have been set up way back in the 1920s. So we are comparing 100-year setup, establishment, the kind of procedures they followed. They must have faltered in the first few years of their establishment, I'm sure. And I think India can become a global hub of arbitration. It can reach that level. It's just that we need to find more answers to questions like, are we really...
Sorry. Closer to the...
Are we really advising the clients to go for arbitration and to also opt for institutional arbitration? We as lawyers, I would obviously take the blame myself. If I'm advising a client tomorrow, I would possibly go for the SIAC arbitration or the ICC rules because I find comfort in them. We've still not reached that level yet in terms of Indian institutional arbitration. And I feel if we are looking at great, robust arbitration practice, we need some more time. There needs to be a little more patience, little more time, little more self-introspection is what we're looking at.
Very interesting. I mean, you're talking about time and patience. Being a younger practitioner, that's really heartening to see. Sorry.
Yes, I just wanted to complete the question that you had asked. So going from my personal experience, I've been in the practice for a couple of years. So I was a part of an execution of a foreign award, which was discussed quite, it was quite popular. It's still going on. So an award which was passed in 2016, being executed and not being, the decretal sum not being recovered is something that is a reality of arbitration in India as on date. So even if it's a foreign award, the execution process is something that we really need to look at.
True. That's right. In fact, that kind of creates a lot of negative publicity, if one may say so, for India. Pallavi now coming, raising the bar again and coming to like me, a slightly more senior little bit.
Yeah. Okay, he's just commenting on how old I am now. That's very interesting.
Right.
Yeah.
So what do you see? I mean, we were talking about enforcement. That's as what she put out. What do you see are the major challenges in enforcement?
I think right now the major challenge is that everybody is hungry and they want to head off for lunch. So I'll make it very quick.
Let's enforce that as quickly as
Let's just make it very quick. So I think the biggest challenge that we all face right now is with the execution part of it. I was in a conference a while back, and there was this GC who was there, and he said, I'm sitting on 700 crore worth of awards and I have no execution which has taken place. And that's the shocking truth. As a matter of fact, last year, you would remember, sir, Justice Amarchand had actually come out with an order where he said that, it's important that domestic arbitration, in order to streamline, there should be more commercial courts which should be in place. He was giving an order in reference to an award which was passed some 30 years back. That was Justice Shah and Justice Nagaratna's bench, I remember, May 20 last year. And that's the reality of the situation. So even if there is an award, the execution is actually not taking place. And that, unfortunately, is the reality. If you are a Supreme Court practitioner, you would know how there is so much difficulty in terms of appointment of international arbitrators just now. We've just come up with a list where there are so many matters which have been pending since 2016, waiting for an appointment itself. I remember I had filed a matter in 2018 where the appointment has still not taken place. It's been 5 years. So therefore, I think these are the challenges that we are facing just now, which I believe that, it can only be the changes can only be brought about with suitable amendments. And for that to happen, I think we still have a long way to go.
No, absolutely. I'm looking at these, and these are certain general comments which I can ask any of the panelists to comment on. You see, one thing we need to keep in mind is execution brings about a bad name for India because of the slow execution. But more importantly, even setting aside of the award, because if India is to be the hub or the seat, the more important thing would be that it's the country where you will go for setting aside of the award or challenging the award. How are courts reacting to that? So of course we have Delhi High Court which reacts very well. But there are other courts which may not. I mean, I remember the Balco case. That was the case which I was involved in on seat of arbitration.
Absolutely, yeah.
But I remember when it first came into the chambers, and we had Mr. Sundaram at that time, and he said, just file it in the district courts in Korba. And, you had Katsi coming down with their whole team every time, and I used to go alone. He didn't even go there. Mr. Sundaram didn't go there. I used to go there and represent. And they were tearing their hair apart as to what is happening.
Absolutely.
So I think we come down to this issue of setting aside sensitivity about arbitration and not interfering. And what I seem to understand is judges feel if there's something unfair which has happened, I must intervene, whatever be the award. Yeah. And this is happening in domestic awards. Absolutely. But it is giving a bad name for foreign. So any of the panelists, if you wish to comment on this aspect.
So,
yeah.
Interestingly, I was just involved in a matter which was, it was between an e-commerce company and another retail company. And we were looking at a very expedited emergency arbitrators award, and we were before the courts and we were expecting them to pass an order. And the day we got an order from the single bench that, yes, it is an order under 17(1), that very night the appeal was filed before the division bench. And of course, the consequences led to 6 months delay in the entire procedure. And the reality is that we are faced with such repercussions, such interference from the court. Whether it is legitimate, whether it is called for, is a separate question. But the point is, courts are interfering, courts are delving into merits, and at a very microscopic level where they are not required to do such things. But the good part is that we come up with judgments by Justice Nariman, who passed the final order in this case. And we finally have some recognition, and the law point that we were discussing has been recognized. So yes, India is moving towards a pro-arbitration approach, but at the same time, we have some hurdles which we need to take care of.
Absolutely. Any other
panelists? So if I may add to what she had just mentioned. See, therefore I started, what I wanted to share with you guys is the sentiment. What is the sentiment not just of the lawyer or of the judges sitting in High Court or Supreme Court, is the sentiment of, at the end of the day, it is the client who are opting for this arbitration, what they actually want to do. While we say that one side wants their arbitration to reach to a finality and getting enforced, but there is the other side who is going and filing a challenge to it in a court.
Yeah.
So, in my view, what is important is for the parties and the stakeholders as well to understand as to what they want to do with their dispute. Because, you know, and a fine balance has to be made. Now, the other thing is about cost and quality. Now, most of the time, generally, cost is indirectly proportionate to the quality. That may be said. So, while we may be in a haste or in a hurry to get something enforced, there has to be a quality which has to be maintained. So, I personally believe, this is my personal view, that efficiency and efficacy can't be at the cost of quality. So quality has to be maintained, and therefore what becomes very crucial is that you have institutional arbitrations or arbitrators otherwise of high integrity, high efficacy to them, and they are honored. So if Justice Nariman is passing a judgment, it is given a great rate of relevance or importance. Why? Because everybody knows his caliber in his intelligence. So that if you have an arbitrator panel or an arbitrator of that level, you will also think twice, thrice before going in challenge to that. So that's all what I wanted to add.
I think there is just one thing I wanted to add, and this is just taking off from where Vikash left. This is primarily with the judges. You know, when the appeal goes, a lot of them, especially in Delhi High Court just now, do not want to entertain it. Just because they want to make sure that, you know, unnecessary appeals are not coming in. That kind of sensitization or rather capacity building needs to be done for the lower judiciary as well.
Yes.
Especially in the commercial courts, because that is where we are finding that we are sitting on awards where the appeal has been pending for 6-7 years and nothing is happening.
Correct. Absolutely.
Just to add to that, so I think the jurisprudence has been consistently changing over the last decade, and India is definitely becoming more pro-arbitration. The setting aside of awards has also comparatively gone down when you compare it to the last decade. So
No, you're right.
I think
Absolutely.
it's moving in the right direction, and
No, it is positive, but you know, let me warn you. Recently, Germany, of course, it's a civil law country, has passed a judgment where it set aside an award. It was a cartel award. It was by the European Court. It set aside that award and it rewrote the entire judgment saying that this award is wrong, and it interfered on public policy, and it's created ripples. And so for all the lawyers sitting here, please be ready. There may be a lot of enforcement work coming your way in India if there are assets in India from Europe. But what my point is, apart from the money, which we may all look at, and
that's
quickly
making my eyes shine right now, you know.
quickly move for enforcement for lunch or otherwise. But the point is that there is no trajectory single. You never know when the courts can take a U-turn. And now these European lawyers were saying we don't want to enforce in Europe because they're not going to enforce the award at all. So we will go to countries where the assets are located, which are going to enforce easily. One quick question and then we can go to the audience. Ad hoc versus this thing. I think one very important point to be noted in ad hoc versus institutional is control. Parties want control of the arbitrator. Bhai, hamara arbitrator hona chahiye, who must be able to understand what we want. I mean, it can go even to darker areas, which I don't want to mention. Everyone understands. But, you know, you get a sense of control. And if you feel that it's only the private sector, no. Public sectors, extremely, their panel of arbitrators, they jealously guard it. Now Perkins and all have diluted it a bit and have created ease. So a quick comment on this ad hoc versus this thing, the sense of control. Parties don't want to leave it. It's not cost. Cost is, in institutional arbitration, 80% is legal costs. The institutional costs are not much. Is that control? So what about that?
So just a quick comment on the appointment of arbitrators and how we think that somebody who's known to us, familiar to us, should be the ideal choice. I mean, all said and done, we all resort to such practices. But in reality, so we are all here talking about impartiality. We are talking about an arbitration bar, how procedural stuff should be in place. We are not understanding that deep within we have these notions that we want to practice. We want an arbitrator who's known to us, who's probably a retired judge. Tomorrow, if a court asks us for 3 suggestions, the first 3 suggestions will be retired judges. So it's practically what we need to implement is very different from whatever we are discussing here.
That's the point.
That's the minor comment that I have.
Absolutely.
And I think that again goes down to mindset. So that control again comes from the comfort of knowing that this is the person I want to appoint, etc. So it's all tied in with, the mindset, which is of course taking a long time to change, and I'm guessing it's a long way.
Well, mindset and also money factor involved. You want to win the arbitration. So, there's a lot of pressure on companies and on lawyers. And if you can't. Shruti, you have to say something. You've been quiet for quite some time.
No, I think I've been waiting for my turn to come, very interestingly. So there are 2 points. One, I think this control is not just an Indian mindset. It applies internationally. That's true. But I think outside India, the fear is to not come across as controlling on the arbitrator.
Correct.
And people are much more willing, including the companies, the parties, counsel, to actually give up that control, to have a transparent practice in arbitration. And that's what makes those countries international arbitration hubs. So we need to actually introspect, like Samridhi said, to see where exactly do we want to go? Do we want to retain that level of control as a profession, as parties who do believe in arbitration? Because a lot of commercial clients do now want to give preference to institutional arbitration, specifically because it's easier to enforce those awards. And all of you probably in your practice have seen that enforcing an institutional award is easier as compared to an ad hoc award.
Ad hoc award. Yes, absolutely.
And just going back to the last discussion that we had, in my experience, I've seen ad hoc arbitration awards being enforced, domestic arbitration awards, in India within a period of 1 year. A very recent example was in Madras, before Madras High Court. And similarly, even before Delhi High Court, which is known for very expeditious enforcement, there have been matters which have been hanging for about 12-15 years.
Yeah.
In a recent matter that I did, and a PSU is of course involved, Middle Eastern party has very happily taken a judgment from a smaller Middle Eastern state against an Indian party, on which it's been sitting, and it's a positive judgment, for about 4 years. And that arbitration is parallelly going on in India. Now, because that arbitration has taken about 8 to 10 years, that judgment itself, which is not really known to the Indian party, is now getting enforced in another jurisdiction, which is also a Middle Eastern jurisdiction, supportive of such enforcements. And the ground for that is delay in arbitration proceedings in India.
Yeah.
So if that delay had not happened in arbitration in India, even though it's an ad hoc arbitration, such situation would not have arisen.
No, very interesting. Interesting point. Time's up, but if I don't know, is the audience, we'd like the audience, if anyone wants to intervene, or I think lunch is beckoning. Right.
If I can just add, sir, one point on this control. I think party autonomy should not be taken to an extent where the parties are, in a manner, at least in their thought process and their and their sentiment, trying to control an arbitrator. See, what my point is that once an arbitrator is appointed, he should act just like I would assume a judge of a Supreme Court is acting, meaning thereby a tabula rasa, without any sort of whatever he shares with the person who is appointing them. And therefore, then again, institutional arbitrators becomes more important, because you are then choosing from the panel which is already there, existence. So what is important is the impartiality and neutrality of the arbitrator as well. And therefore, I would not want to use the word control as far as the aspect of appointment of an arbitrator is concerned. I'm talking from that perspective.
Actually, I have just last thing to add. I think, even younger arbitrators should also be given opportunity,
Yes.
only because they are now very professional, one. Secondly, they actually look at making sure that, quick disposal. I think that's where the smaller ad hoc arbitrations can actually go. So I feel, that's a interesting
fantastic.
area to look at.
An appetizer for lunch just before you go off, and I'm closing. Interesting thing to note about appointment of arbitrator is that two very important facets, friendship and enmity, which is part of IBA guidelines, has been discreetly left out of the factors to be taken into consideration for appointment. So please keep that in mind. And friendship is well defined. It can be easily defined. If you think friendship is a philosophical concept, very difficult to define, no. So those are not there. So, we have to worry about that. I think make that as the next amendment. And I think India will be well on its way to an international arbitration hub. Thank you.